Yes, thank you, Mr Acting Deputy President, and I rise to speak in support of this Greens legislation, the Trade and Foreign Investment Protecting the Public Interest Bill 2014. The purpose of this bill is to prevent the Commonwealth from entering into an agreement with one or more foreign countries that includes a particular mechanism called Investor-State Dispute Settlement Clauses, or ISDS clauses. The inclusion of these mechanisms is one of the most insidious trends we're seeing in modern trade deals, and I applaud Senator Whish-Wilson's great work in bringing this bill forward and encouraging debate on what it has the potential to not only shape the kind of world that we actually bequeath to our kids and our grandkids into the future, but to fundamentally undermine the rule of law and democracy itself. They're high claims to make. I'm sorry that Senator McDonald's leaving the chamber, because he invited me to answer some questions that he posed, and he obviously isn't particularly interested in hearing those. But indeed, at one point he scoffed at the idea that Chief Justice Robert French of the High Court of Australia may have commented with great interest on the issues that are posed by these ISDS clauses and free trade agreements, and indeed Chief Justice French and many others have raised significant concerns. So I'll come to those in the course of my discussion today. But let's start by asking, why are these arrangements, these ISDS clauses, so troubling? And that's because these are mechanisms by which private investors, corporations who are based outside a sovereign nation with no loyalty, no interest or no concern for the citizens of that nation can take their own action against the sovereign government of the nation and use them to sue governments for huge amounts of compensation if they can show that a government policy or a change in policy has directly affected their profitability or their investment. And in so doing, they can exert a huge influence and control on the laws and policies of nations, irrespective of the will of the democratically elected parliaments in those nations. So this Greens bill is designed to prevent the Australian government from entering into agreements that include these ISDS clauses, to prevent corporations outside Australia from being able to dictate to Australian governments effectively the kinds of laws they can and cannot make, and by extension, of course, given that the laws and policies of governments shape the world that we live in, the kind of Australian society we have. It's interesting, and Senator Milne made this point as well, that we hear a lot about border protection from this government. But when it comes to protecting our legal borders, our legal sovereignty, the right of democratically elected governments in Australia to make laws on behalf of all of us and have those upheld by our courts, this government's a bit silent. In fact, they're highly secretive. So right now we have 12 governments, including Australia, the US, Japan, Canada and New Zealand, negotiating this far-reaching trade deal, the Trans-Pacific Partnership Agreement. Aspects of the Trans-Pacific Partnership Agreement, the TPPA, pushed by global corporate interests, are seeking to radically dispose of government regulation in the name of enhanced global competition. We've been invited by Senator Canavan to give the evidence of our concerns. But the problem is that, of course, these negotiations are conducted totally in secret. So my invitation to Senator Canavan would be, if we have nothing to fear, if in fact these concerns that are being raised not only by the Australian Greens but throughout Australian society and internationally are not founded, then reassure us, show us the terms of the negotiations that are happening and we can all go home. But in fact, this is a situation where these negotiations are in secret, and for the first time ever in trade deals, they will include discussions to get broad agreement to remove what are called unfair advantages from government state-owned enterprises and their impacts on commercial business. One hallmark of the way these deals is negotiated is the Australian public has no right to know what's being negotiated away in our name until the deal is done and dusted, and then it's presented to the Sovereign Parliament of Australia with the only option to vote in favour or against. There's no possibility of changing it. The deal has already been done. So we see in the current negotiations for the TPPA, on the back of global corporate interests and pressure, the US government wanting to include a proposal which would allow foreign companies to sue our government and the governments under the agreement for damages if they were to adopt laws or policies that could harm the investment of these global interests. So even if they are laws and policies made in good faith on behalf of the national public interest, laws which may protect public health or the environment, there would be the capacity for outside corporations to challenge those laws and seek large amounts of compensation. And that has a chilling effect on the capacity and the willingness of sovereign governments to actually govern in good faith in the interests of the national public. As my colleague, Senator Whish-Wilson, has already said, clearly what we have set up in these kinds of modern trade deals is a parallel system of governance. It's a parallel system of governance which gives corporations the right and ability to impinge directly upon our ability as parliamentarians to enact legislation in the public interest, and in the end, isn't that what we are elected to do? These ISDS clauses have excited huge concern both nationally and internationally, and indeed the issue has received serious consideration from many, including High Court Chief Justice Mr Justice Robert French, who's the most eminent judge in Australia. And Chief Justice French addressed the Supreme and Federal Court's Judges' Conference in Darwin last year. It's a very thoughtful paper that he has provided, and I commend it to those who are interested in learning more about the nature and implications of these ISDS clauses. And in fact, Senator McDonald expressed disbelief that Chief Justice French may have been commenting on these issues, so I will pay him the courtesy of forwarding a copy of the paper to him, and I hope that Senator McDonald will read that. Chief Justice French focuses on the tensions that can exist between these ISDS mechanisms and the legitimate functions of the legislative, executive and judicial branches of governments. And I would suggest who would be in a better position to be able to consider these issues in a scholarly way, with respect. He sets out the current landscape and, importantly, the implications for the rule of law in Australia. Where there's dispute about the effect of government policy or lawmaking on corporate interests under these agreements, there's a mechanism for that dispute to then go to a system of arbitration. And there have been a great number of concerns about the conduct of the arbitration bodies as they have operated previously when considering disputes under these clauses. So effectively, if there is government policy or lawmaking, and even indeed decisions of courts within a sovereign jurisdiction, if a third party outside that sovereign nation wants to dispute the decision or the law or policy, they can then take these to an arbitration body. Chief Justice French, in his paper, refers to a briefing paper prepared by the European Parliamentary Research Service in January 2014, which describes the concerns raised about the vague formulation of major treaty provisions, which leave a wide range of interpretations open to the arbitrators. So there's a vagueness and an uncertainty in scope and application, which is always a problem in relation to the law. There are also loopholes in these agreements which can lead to abuses such as nationality shopping by companies, which then create subsidiaries abroad specifically to take advantage of the agreements. And indeed, that's what we've seen in the case, the Philip Morris tobacco case, that has been referred to by many of the people making a contribution to this debate. As for the conduct of the arbitration panels themselves, particular and worrying concerns have been raised. As Chief Justice French states in his paper, arbitral tribunals set up under ISDS provisions are not courts, nor are they required to act like courts. Yet their decisions may include awards which significantly impact on national economies and on regulatory systems within nation-states. Questions have been raised about the consistency, openness and impartiality of decisions made in ISDS arbitrations. The briefing paper from the UN sets out some specific issues that have been raised: a lack of transparency with varying degrees of secrecy attaching to arbitral processes depending on the institutions or rules which are applied, a relatively small pool of arbitrators. Arbitrators appointed to ISDS arbitrations are said to be mostly male, and I guess there's no surprises there, 95% of them, and from Europe and North America. Role swapping by arbitrators who appear from time to time as counsel in ISDS cases. So sometimes they're on one side of the bench and sometimes they're on the other. The high cost of ISDS arbitrations, estimated by the OECD as averaging about $8 million each. And associated with the high cost and potentially high awards, a growing phenomenon of third-party funding of claims by banks, hedge funds and insurance companies in exchange for a share of the proceeds from 20% to 50%. So a little bit of a variation on the no win, no fee, or we'll fund it and we'll get a cut of the proceeds, a cut of the win, which is always a real concern in terms of corrupting processes. The absence of effective review or appeal processes and inconsistency in decisions on similar provisions. It's important to understand that this isn't just a vague concern. This isn't just a theoretical concern that we're dealing with here. This is a live issue. There have already been many cases on foot. Last year, the UN Conference on Trade and Development, UNCTAD, published its annual review of ISDS cases. 57 new cases. These are cases brought by outside parties, by corporations against governments, were commenced in 2013, 57 cases. And that was just below the number in 2012, which was a record year with 62 cases. Most of the claims were brought against nation-states by investors from developed countries. No surprises there again. And mainly by investors from the European Union and the United States. And what sort of cases were these cases being brought by these corporate interests? Well, they involved challenges to a range of governmental measures, including measures relating to renewable energy. Now, why doesn't that surprise me? And who would be bringing those kinds of cases? Measures allegedly affecting expropriation of assets, revocation of licences and permits, regulation of energy tariffs. A big one, isn't it? Energy into the future and the profits that are to be made there. Wrongful criminal prosecutions, land zoning decisions, invalidation of patents and sovereign bonds legislations. As I said, many would be aware of the Philip Morris case, where the Australian High Court upheld the validity of legislation made by the Australian Parliament to introduce plain packaging for tobacco products. The challenge was brought by companies supported by Philip Morris Limited against the Australian High Court, but the legislation was upheld. 4 months before commencing the action in the High Court, Philip Morris Asia Limited moved to acquire an interest in Philip Morris Australia, so that it then had an interest in this subsidiary, and that interest is said to have reflected and I quote from Chief Justice French's paper here, the acquisition by Philip Morris Asia into Philip Morris Australia is said to have reflected a tactic used by private investors seeking to take advantage of bilateral investment treaties and is known as either nationality planning or treaty shopping. It appears to have been related to the existence of a bilateral investment treaty between Hong Kong and Australia. That was, and I'm not quoting any longer, but that was a treaty from 1993 which included an ISDS clause. On the basis of that clause, Philip Morris is challenging the Australian government for compensation on the basis of the plain packaging laws, and we'll be interested to see what occurs there. The Australian Greens are significantly concerned that these sorts of clauses and the action that it allows corporations to take against the Australian government and state governments have the potential to shape the kind of world we are going to be leaving to our kids and grandkids. And to bring that home and to illustrate why I'm concerned, I'm going to tell you about a visit that I had last Sunday when I travelled to an area near Mount Gambier in the southeast of South Australia. And I attended a celebration there, which was a declaration by a small land area near Millel, the little town of Millel, where there was a declaration by the residents of that area of their roads and their region being gas field free. Currently there are 2 exploratory drilling wells from Beach Energy in that area, looking for the viability of shale well, unconventional gas mining. And there's increasing concern among the residents in that area about the risks associated with unconventional gas mining and fracking. There are real issues in that area, which is a rich area of agriculture, wine growing, cropping and tourism, and also there is a very limited water supply in that area. So there is a great deal of concern by the residents that unconventional gas mining in that area will actually destroy the viability of the population there, not just the economic viability, but in fact their ability to live there in a healthy way. I went down there and I was absolutely delighted to see an example of citizens, proud citizens, walking up and handing to the Mayor of the District Council of Grant their roles, street by street, road by road, saying we are standing up and saying we do not accept that there will be unconventional gas mining in our area. We are saying we are putting faith in the water and food supplies that we need to protect for our kids and our grandkids. And what I saw there was a strong vote of confidence in what is real democracy, which is requiring decision-makers to make decisions that are in the interests of all people and not just the interests of those who have power and influence and are interested in making short-term profits. It's very clear that the ISD clauses that are in these free trade agreements and which will potentially be in this Pacific trade agreement have the potential to stop our governments from legislating democratically in response to community concerns about environmental issues like mining for conventional gas. There are clear precedents for this kind of action by foreign corporations against governments when they are making law and policy that affects, for instance, energy, and that's what we're talking about here. We're talking about moving away from reliance on fossil fuels to having other sources of clean, green energy like renewable energy, like solar and wind and so on. There's an example in Quebec at the moment where, under the 1994 North American Free Trade Agreement between the US, Canada and Mexico, there was an ISDS clause. And on the basis of that clause, there is Lone Pine Energy Company suing the government of Quebec currently for $250 million because it had the temerity to suspend shale gas mining while waiting the outcome of an environmental study into the dangers of that mining, which was brought about because of public pressure from the community to examine the health and environmental impacts of that mining. The government response to the community pressure was democracy in action, and we have a large corporation currently suing the Quebec government to chill that decision in the sum of $250 million. So we have in the southeast, we have an inquiry from the South Australian State Parliament at the moment into fracking in that area that was initiated indeed by my Greens colleague, the leader of the Australian Greens in the South Australian Parliament, Mark Parnell MLC. What happens if there isn't a decision by the state government in responding to the findings of that inquiry? What if, hypothetically speaking, they were to decide there should be a moratorium on fracking in the southeast? If we are subject to these sorts of ISDS clauses in agreements that the Australian government has entered into, there is every possibility that an organisation could then take action against the state government for compensation to prevent that sort of decision being made. We're at a point in history where it's absolutely vital that people's perception that governments are only governing for the rich, the influential and the powerful is changed. There is increasing disillusionment, and I know that everybody in this chamber will be aware of it when you go out and talk to voters. People do not have faith that we are actually fulfilling the trust for which we've been elected, and that is to govern in the interests of all. This is a point in history where we must defend our democracy, and that has to start from the grassroots up. It has to start with respect for people and the national interest. And Australian governments giving up, voluntarily surrendering sovereignty over the policy and law that we make in this parliament is not only foolish and irresponsible, but it's highly dangerous. It's highly dangerous for the future health and welfare of this nation, but fundamentally I believe it's highly dangerous to being able to remain a viable democracy where our populace has faith in the decisions that we're making. If we lose that, I don't know what we'll have left. I urge the Senate to support the bill.
Your time has expired. Thank you.